It's just another way of communicating messages, a more democratic one and a more pervasive one, but certainly just another way of communicating messages. And when you communicate messages, you're subjected to a variety of different liabilities. When you put information out there on the internet, there's just a whole host of potential claims that can arise out of that, and claims that I handle on a regular basis for a variety of different ways relating to people's websites. Certainly defamation. If you say anything defamatory or disparaging about somebody that tends to hurt their reputation or injure them in their business or calling, that can give rise to a defamation claim. So when you've got blogs, you've got Facebook, you've got any kind of site where people are talking about each other and saying things about each other, you've got a potential for defamation liability there. Second, there's a broad category of these invasion of privacy torts that have been around for about 100 years. The courts have tended to, and legislatures with statutes have recognized these 4 basic torts, and these are claims that come up all the time through things posted on the internet. The first is an intrusion claim, where you intrude into the seclusion of someone else or into an area or a bit of information that they had a reasonable expectation of privacy in. Getting into somebody's computer to get their personal information, you can have an intrusion claim. So those come up often. Second would be private facts. This is one we'll see quite a bit of, and I think there'll be a lot of litigation on this. When you reveal truthful information about somebody, but it's deemed private and would be highly offensive to a reasonable person that it be disclosed, and it's not otherwise newsworthy or of legitimate public interest. In facts case, and there's going to be a lot of litigation, I think, about that, because there's just a lot of people talking about what's going on in everybody's private lives on the internet. Third privacy tort would be a false light claim. I tend to call it defamation junior. It's very similar in a lot of ways to defamation. This is where you're saying something false about somebody, but it's not necessarily defamatory in the sense that it would cause everyone to shun you and treat you with contempt, but it's more offensive and objectionable and embarrasses you and hurts your feelings. And then the fourth one, and this is an area that I litigate extensively in, is misappropriation, I think better known as right of publicity. And that is when you use somebody else's name, likeness, identity for your own advantage, not necessarily commercial or not, but just to gain some advantage without permission. There was a recent lawsuit filed against Facebook having to do with the like feature on Facebook. And when minors like a company and then Facebook puts that out there that, hey, these people like this company, there's been a claim asserted that's saying, well, you're using those minors' images to help promote that company, and that violates the right of publicity. The right of publicity type claim, there's no sort of state of mind requirement. I didn't mean to. It doesn't matter. If you use somebody else's image without permission to your advantage, you can have a problem with these kind of claims. So I think a lot of these are going to come up over time. It's so easy to grab someone's image and throw it into an ad or throw it into something. You know, we sort of talk in the vernacular of celebrities and people out there. It's a natural thing to do. But doing that gives rise to a lot of potential claims, because any time you use somebody's name to draw attention to something commercial, you're going to have a problem.